Rule 112 Preliminary Investigation. Rule 112 of the Philippine Rules of Criminal Procedure outlines the procedure for a preliminary investigation, which is a critical process in determining whether there is sufficient basis to file a criminal charge against an accused. The Supreme Court of the Philippines has provided interpretations and clarification on this rule to ensure it aligns with the due process right of individuals. In Section 1, purpose of preliminary investigation is to protect innocent individuals from the expense, stress, and stigma of criminal trial when there is insufficient evidence against them. In Section 2, who may conduct preliminary investigations? Under Section 2 of Rule 112, a preliminary investigation may be conducted by provincial or city prosecutors and their assistants, national and regional state prosecutors, and such other officers authorized by law. In Section 3, stages of a preliminary investigation. Under this rule of 112 follow several essential stages. Filing of the complaint. In Section 3, the complaint and supporting documents are filed by the complainant. Counter affidavit. In Section 3, the respondent is given a chance to submit a counter affidavit and any evidence within a specified period. Clarificatory hearing. In Section 3, at the prosecutor's discretion, a clarificatory hearing may be held if there are points needing further clarification. In Section 4, which is determination of probable cause. Probable cause refers to facts and circumstances that would lead a reasonably prudent person to believe that an offense has been committed. In Section 4 of Rule 112 requires the investigating prosecutor to determine if probable cause exists after assessing the complaint, counter affidavits, and any submitted. In Section 5, resolution of the prosecutor. After evaluating evidence, the prosecutor issues a resolution either to file a criminal case or to dismiss the complaint. In Section 4, Rule 112, the resolution must be in writing and based on a thorough analysis of the facts. In Section 3, which is filing in court, if probable cause is found, the prosecutor files the information in court. In Section 7, judicial determination of probable cause. Although the prosecutor's finding of probable cause is significant, the court is ultimately responsible for issuing arrest warrants. As stated in Alado v. Jokno in 1994, the Supreme Court has consistently ruled that judges must independently assess probable cause based on prosecutors' evidence to prevent abuse of authority and protect individuals' rights. In Section 8, remedy for aggrieved parties. If the complainant or respondent finds the prosecutor's resolution unjust, they may file a petition for review with the Secretary of Justice, as stated in Agustin v. Pamintuan in 1997. The Supreme Court clarified that a petition for review with the DOJ is not a mandatory part of the PI process but is a remedial recourse for parties seeking further review. And Section 9, limitations and timeliness. The revised rules ensures that PIs are conducted within a reasonable period to avoid delays in justice system.